The Art of Settlement Compliance video blog is a monthly update presented by Synergy Settlement Services. Synergy allows trial lawyers to focus on what they do best by handling the difficult issues at settlement. The Art of Settlement Compliance blog provides trial lawyers with both substantive subject matter expertise related to settlement compliance, as well as important content from leading trial lawyers from across the country. My name is Jason Lazarus, Chief Executive Officer of Synergy Settlement Services. I would like to welcome you to this month's edition of the Synergy CEO's Art of Settlement Compliance vlog. Before beginning today's vlog, let me take a moment to tell you a little bit about Synergy Settlement Services. We provide efficient healthcare lien resolution, cutting-edge Medicare secondary payer compliance services, settlement consulting and planning, critical government benefit preservation techniques, structured settlements, easy-to-use trust services, and lastly, solutions to defer taxation of contingent legal fees. Everything that arises at the end of the case that can be complex and cause issues at settlement with getting to a compliant resolution are things we can help with, what we call the case after the case. By dealing with these issues for you, you get to focus on what you do best, be a trial lawyer. Yes, Medicare does issue refunds. Today's blog will talk about the post-final demand compromise and waiver process. Today's edition of the Art of Settlement Compliance blog, brought to you by Synergy Settlement Services, tackles the topic of post-final demand, compromise, and waiver of Medicare conditional payments. My name is Jason Lazarus, and I'll be your host as well as presenter for today's vlog. So let's jump right in. This issue, the Medicare conditional payment resolution process, is an important one because if you fail to make sure that your firm has procedures and processes in place to ensure Medicare is repaid, you could face government action. And Medicare has done so in two cases over the last 2 years against two different law firms, one in Philadelphia, one in Maryland. Both were the subject of DOJ actions where the government was pursuing those firms because Medicare was not properly reimbursed. And the DOJ put out a statement associated with both of them, and it said the settlements should remind personal injury lawyers and others of their obligation to reimburse Medicare for conditional payments after receiving settlement proceeds for their clients. Pretty cut and dry, pretty clear. It went on to say when an attorney fails to reimburse Medicare, the United States can recover from that attorney even if the attorney has already sent the settlement proceeds to the client. So the government saying, hey, if you send the money to your client, doesn't matter, we're going to come after you, and we can come after you. So the government has become more aggressive about this. One, because they want to protect the Medicare Trust Fund as much as possible and make sure that there's reimbursements when conditional payments are made. But two, also because now under the mandatory insurer reporting laws, Medicare is made aware of any settlement involving a Medicare beneficiary of $1,000 or more, which means that Medicare has at their fingertips information to easily figure out if Medicare is owed money, and they want to make sure that there is reimbursement. I want to talk real quickly, though, about the Maryland case because it's instructive, and I also see frequently on the listservs I participate on as a lawyer that many lawyers will rely upon a conditional payment letter for purposes of figuring out what the Medicare amount is owed, and that is unfortunately a bad practice. And the reason being is in the Maryland case, you had the firm getting a lien amount from Medicare via a conditional payment letter. That CPL for short said that what was due was $14,990. The firm settled the case based upon that amount, telling the client that was the amount. They were aware that there were other medical bills apparently outstanding that had not been paid by Medicare yet. So they settle the case, they notify CMS, and 60 days thereafter, they get notification that the conditional payment amount is $330,000. And they went through the appeals process to appeal that amount, saying, hey, we were told it was $14,990. That appeal was denied. Ultimately, the U.S. Attorney's Office became involved, sent a letter demanding payment, and then the law firm turned over the matter to their E&O carrier, who paid a reduced amount. So the lesson is, make sure that you know what the Medicare conditional payment amount is after you settle the case, and send in your final settlement detail, because that's what's going to trigger issuance of the final demand. And along those lines, I wanted to just briefly talk about the process that you go through when you represent a Medicare beneficiary. So when you undertake that case, you want to report the case to the BCRC. The BCRC will issue what's called a rights and responsibilities letter. Shortly thereafter, they'll identify interim recovery amounts and issue the CPL. Again, you cannot rely upon that CPL, but what you do want to do when you get that CPL is review it, make sure you argue and have unrelated care removed or care that should not be on that bill removed, and go through that process. And then once the case settles, provide notice to BCRC, give them the settlement details. The BCRC will then issue a final demand. If you don't pay the final demand within 60 days, then interest starts to accrue. And after 90 days, it gets referred over to the Treasury Department for collection efforts. So it's important to understand that if you don't pay within that 60-day time frame, that interest starts piling up. And if you request an appeal, or if you ask for a compromise or waiver, that does not toll interest from running. And interest is due and payable for each full 30-day period the debt remains unresolved. And by law, any payments that are made are applied to interest first, principal second. And once Medicare does receive payment, they will issue a letter saying that the case is zeroed out and closed on Medicare's book. So when a case is resolved and you want to resolve the Medicare conditional payment, there's basically just three options. First is you pay the amount after you've done the audit and verification, make sure all unrelated care is removed. That's option one. Option two is you appeal the Medicare conditional payment amount. That is a very lengthy process, and interest continues to accrue the entire time you're going through the appeal. It is not tolled. And the chances of success aren't very likely. There's multiple levels of appeal within Medicare before you ever get into a federal district court to argue. So in most cases, an appeal really isn't the best course of action or avenue for you to pursue for your client's benefit. The third option is post-final demand waiver or compromise. And what that means is that you pay Medicare and you basically pursue a request for them to compromise partially or waive the entire amount. And if that's successful, then Medicare issues a refund. And there's a couple of different ways and different statutory provisions that you can pursue a compromise or waiver under. And when you do that, it's either through the BCRC or through CMS itself. But there's three primary statutory authorities under which Medicare can accept less than the full amount of its conditional payment. The first is Section 1870C of the Social Security Act, which is done through the BCRC and is a financial hardship argument. So cases where, say, your client's on Medicare and Medicaid dual eligible, those are great cases to make the argument that there's a final hardship by reimbursing Medicare. But you don't have to have that scenario. Basically, you go through a process of filling out what's tantamount to a financial affidavit showing the client's lack of resources, and then argue they are financially destitute or in difficult position, and it would be a hardship to reimburse Medicare. I will tell you, and I'll tell you more about this in a second, but even if a client has a 7-figure recovery, you can still successfully make this financial hardship argument. The next one is under Section 1862B of the Social Security Act, and that's the best interest of the program waiver. That's done directly through CMS. The last one is the Federal Claims Collection Act, FCCA, and again, this is done through CMS. The second and third ones are really your catch-all arguments other than financial hardship. That's where you can make equitable arguments. The best interest of the program waiver is a tougher one to get, but when we're asked to handle a Medicare compromise and waiver process, we will do all three as long as there are sufficient valid arguments to do all three, because there is nothing that says you can't do that. So I wanted to share with you a little bit about the success of these types of methods, because many in the industry will say you don't get money back from Medicare, it's impossible, or it's not something that makes sense. Well, what you'll see on your screen right now are some statistics, but you also see a copy of an actual check. This is a check that was cut by BCRC back to a Medicare beneficiary, refunding the amount that had been paid for the final demand because a waiver was granted. So our lien resolution group currently has a success rate of 77% when we request a compromise or waiver. And in 2019, we've recovered in excess of $1.2 million on behalf of Medicare beneficiaries. The average refund is in excess of $16,000. And since we began offering this service, we've recovered in excess of $6.8 million on behalf of Medicare beneficiaries, which is a pretty incredible number when you think about it, because that is $6.8 million that are back in the pockets of injury victims who are Medicare beneficiaries who need that money to take care of themselves. So this is really important that either you pursue it or you hire a firm like us to pursue it. And again, I wanted to talk briefly about a case example. This particular case was just a tragic and sad negligent security case. A grandmother who was attending her granddaughter's birthday party was shot multiple times. Her daughter, the granddaughter's mother, was killed. The grandmother obviously was terribly injured with 7 gunshot wounds. She had a 7-figure recovery. We were able to get Medicare to completely waive the conditional payment amount based on a financial hardship argument. So again, 7-figure recovery, we're still able to argue financial hardship, and ultimately the client got a check back for the total amount that had been paid to Medicare, which was the $159,061. So that's it. Quick overview of the Medicare conditional payment process and the compromise and waiver process. My name is Jason Lazarus, as I said at the outset, and if you have questions about how this sort of thing works, or you just want to learn how Synergy can allow you to focus on what you do best, you've got my contact information on the screen and a telephone number. And I want to thank you for taking the time to watch today's presentation. Synergy is a resource, and hopefully you'll find that through these presentations you get more information than you thought you might, and get a little tidbit from a practice standpoint.
I hope you found this vlog informative and helpful to your practice. Once again, I'm CEO of Synergy Settlement Services, Jason Lazarus, and if you'd like more information about today's topic, do not hesitate to email me at jason@synergysettlements.com or call me at 877-242-0022. If you need help with a case, need a consultation, or just want to learn more, visit us at synergysettlements.com. Thank you for watching this edition of The Art of Settlement Compliance.